Okay, we've got a special edition of Conduct Detrimental today. On Wednesday, May 25th, the lawsuit brought by John Gruden versus the National Football League was heard in the Clark County District Court in Las Vegas, Nevada, on the National Football League's motion to compel arbitration and the motion to dismiss for failure to state a cause of action. So the league brought two motions to get the case kicked out of court. Joining us right now is front office sports, reporter, analyst, writer, AJ Perez, who's been a frequent guest on Conduct Detrimental. He actually flew out to Las Vegas and went to Judge Nancy Alf's courtroom to watch the proceedings in person. So AJ, I'll kick it over to you initially. I mean, I think we know the result. Can you tell us exactly what happened in a little bit more detail? And thanks for joining us as well.
Yeah, the hearing lasts about 90 minutes. The first thing on the docket was a motion to compel arbitration, which she didn't buy. It was pretty clear that the fact that Gruden sent the emails before he was an NFL employee, this was while he was an ESPN analyst, and the fact that he was terminated, the judge seemed to, on both the motion to compel arbitration and the motion to dismiss, those are very key factors in this, and that she ruled pretty quickly. And sometimes judges go back and think about it, and then you wait on the court file system to see what the decision was. But she was pretty clear that this is going to stay into her court for now. And obviously, the NFL could appeal both those decisions today. And the NFL's been known to do that, as we saw in St. Louis and other cases. So yeah, we'll see. Well, it looks like it's going to move forward, and I think we'll get discovery maybe in the next several months. If this case proceeds and there's no settlement between then.
Yeah, one important point, you brought up the appealability of the rulings. Generally speaking, denials of motions to dismiss can't be appealed, but denials of motions to compel arbitration are considered to be non-final orders that can be immediately appealed in the state court system. So I think you hit upon the next move by the National Football League. They're going to seek appellate review. And I don't know if it goes directly to the Nevada Supreme Court or there's some intermediate state appellate court in Nevada. So that's a really interesting angle. I want to go back to the judge's rationale. This is not federal court where we wait for the full opinion being released on PACER. This is, there's really not that much transparency on the docket. So we're very heavily reliant on what the judge says in open court. So on the issue of the timing of his termination, as well as the timing of the emails, did she rule that the dispute itself did not fall within the scope of the arbitration clause?
Yes, and especially since how do you arbitrate when you're getting fired or getting forced out? I mean, that would seem to be key. The whole timeline, between, and there was a lot of talk, especially by Adam, the lead lawyer for Gruden, basically, who still alleged 2 or 3 times in court today that the NFL and Goodell leaked the documents, and basically created this whole scenario where Mark Davis initially, the first story, which dealt with the Morris Smith, with a racist trope that was published by the Wall Street Journal. That didn't get him fired. So, Gruden's legal team said in court today, so the NFL went a step further and released more emails. And those appeared. Those were the sexist and homophobic emails that the New York Times published 3 days later. And within hours, Gruden resigned under pressure. And there was the fact that he settled with Mark Davis for an undisclosed sum, the owner of the Raiders. The NFL tried to use that, saying, well, he settled with them. He should. He was bound. He's even though he settled with them, he's still bound by the conduct detrimental provision under the NFL bylaws.
Well, how did she deal with the issue of the arbitration provision that was in his contract simply bound Gruden to have arbitration of any disputes with his team, right? It's an employment agreement between Gruden and the Raiders, and any arbitration clause would sort of encompass those employer-employee disputes, and they would be resolved by Commissioner Goodell. I get that, but this lawsuit was brought by Gruden against the National Football League, and I think what the league was arguing is that there was standardized language in the NFL Constitution and bylaws that was integrated, or at least incorporated by reference in the employment agreement, where it doesn't say all disputes with the NFL will be arbitrated by Goodell, but it actually bootstraps indirectly some of the language in the Constitution and bylaws. How did the judge, I guess, divide the issue in thinking about it as a Gruden versus NFL, controversy? Was that central in any way to her reasoning?
Yeah, she spoke really softly, and I'm still going through the audio because
I couldn't
took
even
notes.
hear it. I mean, I was listening
Yes.
to it on Facebook.
So,
It was like somebody
yeah.
snuck in a tape recorder.
Yeah, I know. Yeah, and so I'm going through it, but yeah, she seemed the NFL was arguing today in court that they have an interest in keeping any racist, misogynistic, homophobic, any employee who promotes that, they have the right to sanction them or to obviously terminate them, and that's kind of detrimental, and that's covered by everybody who's an NFL employee, including the players. But the fact that he sent the emails before he was a head coach, the fact that he was terminated, he was basically, I don't know, he resigned, but you can almost say he was effectively terminated because of the leaks. And so and while we would love to know where they came from, and the NFL denies it was from them, and I think that's not even the biggest part of the case right now. I think that the judge found that the timeline mattered more than who leaked these and why. And I think that was it. I think that was even though there's a lot of arguments in court today about on both sides about where the NFL Constitution and bylaws starts and ends. I think that the timeline of how it all went down, and including when those emails were sent, were pretty crucial.
All right, I followed your timeline today on Twitter, and maybe I made more of this than you intended, but you included a disclosure that came from the NFL's outside counsel. I don't know if he was pointing the finger at the Washington Commanders, but he indicated that the Washington Commanders were the entity that disclosed these emails to the NFL, and it didn't come through Beth Wilkinson's investigation. It was reported directly by the Commanders at the time, the Washington football team. How significant was that, and what do you think that means? Is it suggestive that maybe Dan Snyder is behind this?
I don't know if it was Dan Snyder. I think this was all, these were all procured during during Beth's investigation. But it was just me. I have to go back to look through all my reporting before. This is the first time I've heard like the provenance of the emails, where they came from. Obviously the NFL had them. I didn't, and they could have released them to somebody, and they still have them. But the kind of the intermediary, like how did the NFL get them? And apparently it was, I don't know how the servers work in the NFL, if every team has its own server at the NFL.com domain, or the league office has those, and can just request those from the team. So
it could have just been produced as part of a massive document dump, and not necessarily singled out by individuals looking to tarnish John Gruden or Bruce Allen. So maybe I read too much into that.
Yeah, I have to go back and listen to that again, because that was very interesting to me, that it was, this does link back to the Commanders. I'm not saying Snyder okayed the IT guy to give the NFL the emails. We're so far from that, but that's what the lead attorney for the NFL said today, that it was, the league got these from the Commanders.
Okay, I want to go back to a central theme. I've been writing for months that there's a snowball's chance in hell that a Nevada state court judge will kick this over to private arbitration, because you're asking a court to accept the notion that an NFL employee can be the adjudicator of claims brought against his own employer, like tort claims. There's an inherent conflict of interest there. And I've written about this, and I wasn't surprised by the result, but when I listened to the playback or listened to the live court feed, I heard Judge Alf, use the words procedurally and substantively unconscionable. Did Judge Alf speak at all to the issue of the unfairness or the conflict of having an NFL employee be the arbitrator of tort claims being brought against the NFL, which, by the way, pays this employee $60+ million a year? Did that bother her or seem concerning to her?
Her rulings were so concise that she didn't really weigh into that part of it. It was basically, both rulings took about a minute and a half for her to discuss. And she did and the only time she piped in I think I have it. I have it on my story. Was when she only piped in really once or twice during it, and it's like, and she made the comment, these emails were sent before we signed the contract, and I having brackets to become the Raiders coach. That was the only time she piped in. She just kind of matter of factly made those rulings, and didn't really give us too much of a glimpse into why outside of she did state some that state law kind of took precedence, obviously, over the NFL's constitution and arbitration in this case.
Yeah. Was there any indication from Judge Alf that she's going to issue a written opinion? I imagine she has to, because if the NFL is going to appeal something, you can't just appeal an oral, I guess owner tenant, whatever they call that. I haven't litigated in 2 years. I forgot the Latin name, but this ruling has to be reduced to writing. Did she give any indication as to the timing of the release of her ruling?
She spoke so softly that she may have, but I don't think so. I think, I would expect one within a week, just so, like you said, that if the NFL decides, especially for the motion to compel arbitration, if they want to appeal that part.
So AJ, what's coming up next? We obviously facing the next, gauntlet, which is discover, okay, the NFL is going to appeal the arbitration ruling and maybe the motion to dismiss if they can.
Motion to seal is going to be next. Yeah.
Wait a second. Was there another motion that you heard today on the motion to seal records? Okay.
No, there was an initial motion right when court started it was a motion to seal. It was a motion. They didn't seal the NFL bylaws, which is open record anyway. I mean, we already have access to that. There was some other employment. I think there was, and it was very early on. There was a motion to some employment information. I think that was like some kind of details that were sealed. But it was not. It didn't go into everything. So.
Okay, so the next step besides the appeal is going to be the march forward towards discovery. Did she discuss with the parties anything in the nature of a schedule, a timeline for discovery? Did the lawyer for John Gruden indicate what he was prepared to do next and when?
No, there was no, she didn't lay out the schedule. I expect that'll be kind of input into the system within the next few days, the next hearing. And there was no other timetable set. And as far as the lawyers talking, neither side talked to me afterwards. I'm still hopeful that Gruden's lawyer, I talked to Gruden briefly. That was cool. I approached him in front of the elevators and got yelled at by the court staff, who I was like, "Well, I'm from out of town. I have no idea what your rules are." I love, that's all.
What are the rules? You can't talk to a person.
You can't do interviews in the hallway, which I've known that's the rule at several courts around the nation, but I've never covered anything here in Nevada that I remember in person. So I can just claim, I had no idea.
The judge spoke very infrequently during the proceeding, and when she did speak, her voice was kind of faint. Was there anything in the nature of a hot bench where she asked the lawyers questions during their argument?
There were a couple of questions asked, but it was kind of they were brief, and I maybe one, and like that was. And she just made a couple points during it, but she was basically just let the NFL talk, let Gruden's lawyer talk, and the rebuttal from the NFL lawyer, and that was it. Pretty much, it was that was the same way it played out. The motion to compel took a little longer than the motion to dismiss, which makes sense since there were a lot of the same arguments. So that was that, and now we're kind of in a place waiting for the next step here.
Well, the next step is going to take quite a while. I mean, you might have just witnessed the only significant in-court proceeding in the Gruden versus NFL case for the balance of 2022, because the rest of it is just going to go through the discovery process, and it won't surface in the court again unless there's a discovery motion or a motion for summary judgment. But I think the MSJ motion would probably be sometime next year. They may need a lot of runway to conduct discovery. So the next real in-court proceeding might be the appellate oral argument on the motion to compel arbitration. So any chance you're going to stay in Las Vegas for the next couple of months waiting around for it? I mean, it's very, I know you had to make a huge sacrifice to go to Sin City. So you don't look like you're staying at the Wynn Encore. I'm looking at the background in your hotel room. What kind of a budget did they give you?
No. A good one, but it was this was not a cheap trip with as you know the price of flights right now, but it was something I think it was crucial to be here, and I'm also covering a couple other things here, and I'm going to go trying to poke around LA to get some stuff on the Angels next. So we'll see what
Okay.
goes on.
Well, enjoy the rest of your time in Las Vegas. I'm sorry.
Breaking up. 1 second here. I just got something from the NFL. Let me see what it is.
Breaking news on our podcast, which we're going to release quickly.
So, all right, here we go. We from the NFL statement, we believe Coach Gruden's claims should have been compelled to arbitration, and we will file an appeal we'll file an appeal of the court's determination, and the court's denial of our motion to dismiss is not a determination on the merits of Coach Gruden's lawsuit, which, as we have said from the outset, lacks a basis in law, and the fact that proceeds from a false premise. Neither the NFL nor the commissioner leaked the Coach Gruden offensive emails. So I'm gonna put that on my story now. I'll tweet that out. So
yeah, I mean, they could appeal, to the Mars Supreme Court. I think the judge got it right in the first instance, but this decision, even a denial of a motion to compel arbitration, is immediately appealable. I expect the NFL to take their shot at it. This has some down the road consequences because Brian Flores is going to be facing a similar motion in the class action lawsuit that he brought against the NFL and the other 32 teams. And right now,
and also, and this is going to be huge. This is going to be huge for the Commanders. I mean, if they get all those emails, this is going to put. That's why there's all the speculation over the last several months of who leaked these emails. Was it Snyder? Was it Goodell? If it points back to one of the two, it's going to put Snyder in a lot more jeopardy, at least a long suspension, if not removal.
Oh, no. Suspension is, forget it. They're going to go right to go, and he's going to be terminated or forfeiting his ownership interest.
Yeah, it takes, I think a long suspension, or the alternative is kicking Snyder out, kind of like what they did with DeBartolo. DeBartolo had his sister take over the team. Will this mean his wife going to take over the team? Which nobody really wants.
Sibling is less immediate than your significant other. Their sister's not insignificant, but that's just a different family. A topic for another day. But there are definitely a lot of consequences that could befall certain parties if this case moves forward. The impact on the Flores case, the viability of Goodell serving as an arbitrator anytime the NFL is sued. I mean, that's definitely in play here because you have now the Gruden decision. You have a state court decision in New York, which held that Major League Baseball couldn't serve as an arbitrator for tort claims being brought against it. I think the league tried to have Rob Manfred, serve as the arbitrator for tortious interference claims brought by the Staten Island Yankees against MLB and the New York Yankees, and a state court judge said, no way, that's a conflict of interest. So the only two cases on point suggest that a sports league commissioner could never serve as an arbitrator when there are tort claims brought directly against his employer. So it's a very important precedent moving forward. AJ, thank you so much for joining us on such short notice and giving us the first deep dive on the inner workings of today's proceedings and how it went down. I thank you very much, and we're going to have you back very soon. So really, really appreciate it, and enjoy the rest of your trip in Sin City.
Thanks for having me in Virginia in a few days after I go to see my parents.
All right. Thanks again, AJ. We'll talk soon.
All right. Got to go. Talk to you later.